Afternoon. If you're joining us from the US, good morning and welcome and thank you for joining us on this Fox Williams webinar, snappily titled Latest Developments in International Data Transfers, the Need to Know Details. My name is Nigel Miller and I'm one of the partners in the Tech and Data Protection Group at Fox Williams. And I'm very pleased to be joined by Ben Nolan, who's one of the associates in our group. In data protection terms, the past few weeks have been what you could call a perfect storm. In July, we had the Schrems II decision of the European Court of Justice, followed up by recommendations from the European Data Protection Board. And we've just had also issued new standard contractual clauses from the European Commission. And just to make it interesting, the end of the Brexit transition period is only a few days away, and we still don't know whether there's going to be a deal or no deal. Now, although there's a lot of detail on these issues, this webinar is relatively brief, and we propose just to stick to the essentials. You can submit questions on the Q&A, but we have a lot of people on the call, and it may not be there may not be time to address them. So please do contact us afterwards if you need any more information or help. This webinar is being recorded, and following the webinar, we're going to circulate a copy of the slides and also a link to the webinar. So there's no need to try and scribble notes as we go through. So here's what we're going to cover. First of all, a brief summary of the Schrems II decision back in July. Then a look at the EDPB guidance on carrying out transfer impact assessments and implementing supplemental measures. A quick look at the new standard contractual clauses, and also a look at the Brexit implications for international data transfers. So I'm going to happily hand over for the first part to Ben, who's going to look at the Schrems II decision. With you, Ben.
Thanks, Nigel, and hi everyone. So as Nigel has mentioned, we're going to start our discussion with the European Court of Justice's landmark decision in the Schrems II case. And this has essentially been at the core of most of the changes to the data transfer regime that we have seen in the past few months. The case was essentially a rehash of the original Schrems case, which came before the European Court in 2016. And in that case, the privacy activist Max Schrems brought proceedings against Facebook and successfully brought down the US Safe Harbor, which was the predecessor of the Privacy Shield. In Schrems II, Schrems complained to the Irish courts that Facebook's reliance upon the standard contractual clauses to transfer his personal data from Ireland to the US violated his privacy rights due to the broad surveillance powers that the US intelligence agencies are given under US law. Ultimately, this led to the Irish High Court referring a series of questions to the European Court of Justice, including in relation to the validity of the standard contractual clauses and also the Privacy Shield as lawful transfer mechanisms under the GDPR. When reviewing the case, the European Court made it clear that the key criteria for assessing the validity of the Privacy Shield and the standard contractual clauses was to ascertain whether these provide a level of protection for personal data, which is essentially equivalent to that set out under the GDPR and European law. So with this threshold in mind, the court ruled that the Privacy Shield does not ensure an equivalent level of protection, and therefore ruled that it is not or no longer a valid transfer mechanism. And there were two main reasons for this. The first reason was that the court ruled that US surveillance laws go beyond what is necessary in a democratic society. And the second reason was that the court found that the Privacy Shield framework did not provide individuals with effective rights of redress against US intelligence agencies where their data has been interfered with. So as a result, the Privacy Shield is now done and dusted. If you're still relying on it as a transfer mechanism, then you need to stop doing so and implement an alternative transfer mechanism, or you need to suspend the transfers altogether. It's also worth bearing in mind that you may also still have references to the Privacy Shield in your privacy notices, and therefore those references will need to be updated in light of the decision. The second and perhaps even more important element of the European Court's decision in Schrems II relates to the standard contractual clauses. And so the court thankfully did uphold the validity of the SCCs, and this is obviously a relief given how widely these are relied upon by businesses that transfer data internationally. But it wasn't all rosy for the SCCs, and the court noted certain shortcomings with these. In particular, the court noted that the standard contractual clauses cannot bind state intelligence authorities, which are not party to the clauses, and nor can they completely override the laws which apply to the data importer in their home country. So the court therefore ruled that parties to the standard contractual clauses need to check before making any transfers under them as to whether these will be effective in ensuring an equivalent level of protection for the data they're transferring. This is where the notion of carrying out transfer impact assessments has essentially been born from. The court also ruled that where the results of the transfer impact assessment show that the standard contractual clauses alone will not be enough to guarantee an equivalent level of protection for the data that's being transferred, then certain supplementary measures need to be implemented by the parties to ensure such a level of protection. So the effect of the court's decision is that now relying on the standard contractual clauses is essentially a much more onerous process than was previously treated as being the case. You can no longer simply treat the standard contractual clauses as a tick box exercise, which has often realistically been the case up until now. And now there are additional steps that you need to take in order to rely on these. The only problem was that following the Schrems II decision, there was a lot of uncertainty as to what was actually entailed in carrying out these additional steps and what was meant by a transfer impact assessment and what supplementary measures might be implemented to ensure that added level of protection. Thankfully now, the European Data Protection Board has issued guidance on international transfers post-Schrems, and we'll discuss these now on the next slide. Thanks, Nigel. So yeah, the guidance issued by the European Data Protection Board essentially sets out a 6-step process which all organisations transferring data outside of Europe must focus on. Notably and importantly, the guidance relates to existing transfers as well as new ones. So it's not just transfers you're making in future that you need to be concerned about. So the 6-step process is set out on the slides, as you can see. The first step involves identifying all the international transfers that you make. Second step involves identifying the transfer mechanisms you rely on for making those transfers. And the third step, and this relates only to transfers that are made on the basis or supposed to be made on the basis of standard contractual clauses and binding corporate rules, and it requires you to conduct a transfer impact assessment. The fourth step, which will apply depending on the results of the transfer impact assessment that you undertake, involves identifying any supplementary measures that are needed to ensure the additional level of protection. And then the fifth step is a procedural step of actually implementing those supplementary measures. The last step involves reviewing transfers at appropriate intervals. So for the purposes of this presentation, we're going to focus on steps 3 and 4, and that's because these are essentially the key new steps that have been introduced to the process following the Schrems II decision. And although these steps are equally relevant to standard contractual clauses, as well as binding corporate rules, we're going to focus more on the standard contractual clauses, given that these are the more common transfer mechanism that's relied on by organisations. So in terms of carrying out a transfer impact assessment, what actually is meant by that? Well, the EDPB's guidance says that this essentially amounts to carrying out a review of the laws and the customs which apply in the country of the data importer and assessing whether these would prevent the standard contractual clauses from working properly in relation to the transfer. Clearly, not all transfers to one country will be affected in the same way once the data arrives there. And therefore, the European Data Protection Board highlights that different considerations will apply from transfer to transfer. So, for example, if you're sending personal data to a tech company in the US, then different considerations would apply than would be the case if you're sending medical data relating to a patient to a hospital located in the US. You may be thinking that the process for carrying out a transfer impact assessment is not going to be an easy one, particularly for data exporters who probably won't have any presence in the country they're transferring the data to and won't have much or any experience of the laws that apply in that country. As a result, the EDPB suggests that data exporters and data importers will actually need to work together in carrying out the assessment. Whether or not data importers will actually be happy to assist in this way is yet to be seen. You can imagine it being more of a problem for smaller data importers that have less resources. The larger organizations may well have large departments that are able to produce standard material on this. In terms of the relevant laws which data exporters and data importers need to be looking out for, unfortunately, the EDPB's guidance doesn't provide an exhaustive list on this, but they do provide some indicators as to the laws which might be relevant when carrying out the assessment. So in terms of positive indicators that can help to demonstrate that a country's laws will allow for the effectiveness of the standard contractual clauses, the European Data Protection Board refers to the factors that are set out in Article 45(2) of the GDPR, and this relates to the factors that the European Commission would assess when deciding whether or not to issue an adequacy decision in relation to a country. So relevant factors here include the fact that the rule of law is respected in the country, and that there is a proper and well-functioning legal system in place in that country, which allows individuals to exercise their rights and seek redress in the events that their rights are violated. Also relevant are the existence of a data protection law and the existence of an independent data protection regulator to oversee that law. In terms of laws that the EDPB suggests could prevent the effectiveness of the SCCs, they refer to laws which would restrict individuals from being able to exercise their data subject rights properly, and laws which would prevent an individual from being able to obtain effective remedies against the importer. However, the issue that's given by far the most attention by the European Data Protection Board are the surveillance laws which apply in the country of the data importer. And this is probably not surprising, given that in the Schrems II case, so much attention was given by the European Court to US surveillance laws, and it was ultimately found that these go beyond what's necessary in a democratic society. So to help data exporters and data importers evaluate the surveillance laws which apply in the country of the data importer, the EDPB has produced separate guidelines called the European Essential Guarantees. And these are quite detailed and legalistic, and we don't have time to go into them in too much detail, but they set out 4 key considerations that exporters and importers should take into account when evaluating surveillance laws. Firstly, the surveillance regime should be based on clear, precise, and accessible rules. Secondly, the regime must be necessary and proportionate. Thirdly, there must be an independent oversight mechanism with appropriate checks and balances. And lastly, there must be effective remedies available to individuals. So in light of the EDPB's guidance, it looks like we're all going to have to become experts in non-EU countries' government surveillance regimes if we want to keep making transfers on the basis of SCCs. And this could be quite an interesting exercise for some countries, And I would even include the UK in that group following the end of the Brexit transition period. Once the data exporter and data importer have completed the transfer impact assessment, the data exporter needs to document this, as is always the case with data protection law. And if the results of the transfer impact assessment shows that the SCCs are not enough on their own to ensure an equivalent level of protection, then supplementary measures need to be adopted and implemented. I'll hand you over to Nigel now, who will discuss these in further detail.
Thank you very much, Ben. So as Ben said, if the transfer impact assessment shows that the country doesn't offer an adequate level of protection, then you have to assess whether you can put in place some additional supplemental measures. If you find that you can't put in place additional supplemental measures to create that equivalency, then basically you can't carry on doing the transfers. So what are these supplemental measures that we can put in place? Essentially, there are three types of measures. There's technical, contractual, and organizational measures. And a combination of all three of these may be needed. And the EDP guidance sets out in quite a lot of detail what they see as a number of examples of each of these areas. And I'll just touch on a couple of them. But the main point is that the main supplemental measure that they focus on are the technical measures. This is the one that they see as being the key. And the other two, the contractual and the organizational methods, are supporting. On the technical side, the main thing here is that the data will meet the requirement for supplemental measures if it's either encrypted or pseudonymized. Now, in terms of the encryption and pseudonymization, to be effective as a supplemental measure, the EDPB say that the data importer, the recipient of the data, cannot have access to the encryption key or the other data that would be needed to unlock the pseudonymized data. So that might be fine if you're just hosting data remotely or backing up data and there's no need for the service provider to access that data. But it's much more problematic if you're sharing data, for example, with a parent company, or you're using a SaaS service where data is being hosted as well, where the provider actually needs to have access to the data in a clear form. And the EDPB make it clear that in that scenario, it won't be satisfactory. Worryingly, they also give the example of where an EU subsidiary shares HR data with its parent company in a jurisdiction such as the US, where public authorities can access that data beyond, as they say, what is necessary and proportionate in a democratic society. And this is a very common scenario, of course, for international groups. And the EDPB conclude that that's not an effective technical measure where the recipient in the US, for example, has access to the data in clear form. So in such cases, it will be probably necessary to do what you can in terms of technical measures, encryption in transit, for example, but also to layer on additional contractual and organizational measures. So in relation to contractual measures, well, we already have the standard contractual clauses, which I'm going to come on to in a second, and they're already quite detailed. But what we're talking about here is SCCs plus, if you like, adding a number of additional provisions to the contractual clauses to give them a bit more oomph. So, for example, that might be enhanced audit rights, or the EDPB give the example of what they call a warrant canary, which for some service providers would involve them publishing at least every 24 hours a cryptographically signed message to confirm that they've not received an order from the government or a police or an enforcement authority to disclose personal data. A little bit paranoid perhaps, but that's one of the measures that they refer to. And organizational measures as well. This is really a bit like the GDPR accountability principle. So bringing in a lot of internal policies within the data importer organization, perhaps under which they commit not to release voluntarily data to government authorities unless they're under a legal obligation to, and also perhaps being backed up by things like training programs and other policies. So there's quite a lot to think about there, and data exporters from the EU and the UK have to proceed with caution, document the assessment thoroughly, as Ben has described, and they will be accountable for the decisions that are taken here in line with the accountability principle. The EDPB say that if, having done all this assessment and put in place such supplemental measures as you can, you still think there isn't there's a lack of essential equivalence, which is what we're looking for, then, and you go ahead anyway with the transfers, then you have to notify the supervisory authority. So in the UK, that would be the ICO. So quite a lot of work to do there on impact assessments and supplemental provisions. I want to turn now to look at the new standard contractual clauses that we mentioned at the beginning, because the next day after issuing the guidance on carrying out transfer impact assessments and supplemental measures, the European Commission published its proposals on new standard contractual clauses. There's a relatively short consultation period. It's actually already expired on the 10th of December. And as Ben's mentioned, the contractual clauses are probably the most commonly used method to authorize data transfers from the EEA. The attraction, at least until now, has been they're relatively easy to put in place, relatively cost effective. But the problem is that they're very out of date. The earliest ones date back to 2001. They refer to the old Data Protection Directive and haven't taken into account the GDPR. And practically speaking, people tend to just sign them and put them in a drawer. And so they don't really do a very convincing job in terms of protecting personal data. So it was always the intention to update the SCCs to reflect the GDPR. 2.5 years later, we're still using the old ones, but now we have proposed new ones, and they do have some interesting features to them. I'm just going to mention a couple of them now. First of all, whereas at the moment we have basically 3 sets of standard contractual clauses, 2 sets for controller to controller transfers and 1 set for controller to processor transfers, we now only have 1 set of standard contractual clauses, but they cater for various transfer scenarios. They cater for 4 different scenarios. So the controller to controller, controller to processor, but also processor to sub-processor, and the reverse transfer processor to controller. Those last 2 ones we don't currently have SCCs for, which can be problematic, but the new SCCs hopefully solve that problem. In respect of transfers by a controller to a processor, the new SCCs also meet the requirement in the GDPR under Article 28 for data processing provisions. So whereas at the moment you might have to supplement the standard clauses with additional data processing clauses, going forward that won't be necessary. But we do see one potential issue with that is, as many of us will spend a lot of time negotiating liability limits and caps on liability in data processing agreements. The new SCCs say that each party is fully liable for any damage it causes as a result of its breach. Meanwhile, the SCCs also say that they will prevail over any conflicting clauses in any side agreements. So the question here is whether any liability caps that you've agreed in data processing agreements will be overridden by the standard contractual clauses, unless you can find a way to draft them in a way which is compatible with the standard contractual clauses. The fact that all this has come together, what I called at the beginning a perfect storm, is probably no accident, because they wanted to make sure that the standard contractual clauses that they introduce are compliant with the Schrems II decision and follow the guidance that's been issued, with a view hopefully to them not being vulnerable to further legal challenge, which of course is always possible. So the new standard contractual clauses do take into account the Schrems decision. For example, they have a provision that if the importer is subject to a legal requirement to disclose data to a government department, then they must first inform the data exporter where possible, And there's a commitment to exhaust all available remedies to challenge the request. So it's quite an onerous obligation on the part of the data importer to do that, to try and challenge any requirement from the local enforcement authority to gain access to the data. So what do we need to do given all of this is happening? Well, the new SCCs are not yet actually in final form. They may be subject to certain changes. Once they've been approved, which may or may not be before the end of this year, or it may be early in the new year, there's going to be a transition period of 12 months within which we have to replace all the existing old form standard contractual clauses with the new one. So it's going to require a lot of repapering of existing contracts. During this period, we can continue to rely on the existing SCCs, so for another 12 months or so. But we do have to nevertheless get on and start looking at the transfer impact assessments and supplemental measures in the meantime, because there was no transition period for that. And I can see questions come on the Q&A about whether those things applied retrospectively. And I think if that's referring to the consequences of Schrems and the guidance on TIAs and supplemental provisions, then in a sense, yes, there was no transitional period for that, and that's immediately live, although there is going to be a transitional period for these standard contractual clauses. In practice, I think many organisations will take these things together. Okay, I think I might have just gone backwards or forwards. Anyway, I'm going to come on now and just on the final slide, look at Brexit in the last couple of minutes. There are obviously a lot of implications with Brexit, but we're just focusing here on the implications for international data transfers. The transition period for Brexit, as everyone knows, comes to an end on 31st of December. So what's going to happen then? At the end of this transition period, the EU GDPR will come into UK domestic law as UK GDPR, and it's basically the same. There are a few little tweaks here and there to make sure that it operates in the UK, but to all intents and purposes, EU law and UK law will continue to be aligned on data protection after the transition period. But what about international transfers to and from the UK? So as regards transfers from the UK, there's no immediate changes. Transfers to the EEA are okay, there's no issues. And transfers to other countries, such as the US or elsewhere, then existing adequacy decisions will continue to be respected, and the EU-approved standard contractual clauses can continue to be used. So that's the good news. There's continuity in terms of transfers from the UK. A bit more difficult in relation to transfers from the EEA to the UK. Once the transition period comes to an end, then the UK will effectively become a third country outside of the EEA. And the European Commission can deem the UK to be an adequate territory, known as an adequacy decision. And that's what we're hoping for as part of a Brexit deal. We're currently going through an adequacy assessment to decide whether we can have it. These things normally take several years, and it's a bit of a stretch to imagine that we will get an adequacy decision by the end of the year, although there might be some sort of transitional arrangement if there's a Brexit deal. If there's no deal, then there will be no adequacy, and we will be a third UK will be a third country. So in that scenario, as we discussed, the most straightforward solution in terms of transfers coming from the EEA to the UK will be to put in place standard contractual clauses. You could do that now in the run-up to the end of the year, perhaps with a condition precedent that they will only kick in if there's a no-deal Brexit, or you could do it early in the new year if you want to wait and see how things turn out. Of course, the position is a little bit more complicated because we've now got the new standard contractual clauses, and it looks unlikely that those clauses will be adopted before the end of the year. So there's still an option to use the old clauses up to the end of the year, or early early 2021, with a view to putting in place the new clauses once they're finalised a bit later on. So a little bit of a messy situation around there. So in conclusion, we've covered a lot of ground very quickly, but it is a really big ask for everybody to put in place transfer impact assessments, implement supplemental measures, put in place new standard contractual clauses, especially for businesses facing already a lot of regulatory and other challenges at the moment, who may not have access to large amounts of resources. But from a legal compliance point of view, it is necessary to start doing something in this direction, particularly in terms of the impact assessments and looking at supplemental measures, and importantly, to document what you're doing, as Ben said. From a practical point of view, there'll need to be some commercial risk-based prioritization of international transfers, where your transfers are using substantial service providers overseas. Then one can hope or expect that they will take the lead on some of this in terms of they have to provide a compliant solution for their customers, which may include things like off-the-shelf assessments. But we should have to wait and see what happens with that. For UK firms, after Brexit, we can look to see whether the ICO will offer any more pragmatic guidance, a bit more pragmatic typically than the EDPB. But there again, they may not be able to do that because if they do dilute the data protection laws to any respect, then that could jeopardize the UK's adequacy decision. So we'll have to see how they manage to finesse that. So as we await these finalization of these new standard contractual clauses, it's necessary to get started on the initial transfer impact assessment, keep these developments under review, and prepare for a busy 2021.